حياتنا. بدي افسر ويلكم. اهلا وسهلا فيكم. This is nice. لإلي انا منيح بس لهم بعدين. I'm very happy to and honored to see all of you and to be chairing this session. And also as one of the organizers of this event, I'm very happy to be here. This is the second year that we are arranging together as academic institutions, but also as feminist organizations, an event that is engaged with gender, religion, and state. Last year, we had this event for the first time. The Gender Studies program at al-Carmel and the Working Group for Equality in Personal Status Laws. Within this program last year, we reviewed the book of the a distinguished book actually of Professor Mikhail Karayanni, and the Professor Mikhail Karayanni was part of this meeting, and he was very interested in this combination between activism and academic analysis. So we thought together to arrange this event for the second year. So I'm very happy that we have it. Tonight the presentations actually will be in English, but the discussions will be in the language that you prefer and you feel comfortable with. Tomorrow we have 3 sessions. The 3 sessions will be in Arabic. And that's it. Again, I'm happy to be here. I'm replacing actually my colleague Bana Shugri, who's not feeling well, and she sends us her wishes for a successful and interesting discussions for tonight. Again, أهلا وسهلا فيكم. I will start with this session. The session, the general title of this session is Gender, State and Religion, the Case of the Palestinians in Israel. So today we will talk mainly, or only actually, about the Palestinians in Israel. And when we say gender, state and religion, we are talking about 3 systems, actually 3 systems of power. And of course our engagement is not separated from the agency and the activism of the woman and our political activism towards changing this situation. So the discussions will take place will talk about the systems, the interactions between these systems, and also the activism towards political change. This session will talk only about the Palestinians in Israel, but tomorrow we'll also have a discussion on one of the Arab states' engagements of these issues, and the most important one maybe after the Arab Spring is Tunis example. So tomorrow we'll talk about Tunisia also. I will start with this session with Professor Mikhail Karayanni. Professor Mikhail Karayanni is the Bruce Wayne Chair of International Law in the Hebrew University, and he's again a distinguished academic and scholar, and I'm proud to have you with us here. Actually, I'm proud of all of you. And I'm happy that you're proud. No, actually, I prefer to introduce you before, and then we will start the settings. So we have also Professor Ayelet Ariel, Professor of Political Science in the Conflict Resolution and Policy and Government sections in the at Ben Gurion University. And we have also Dr. Sonia Boulos. She's a professor of international law and human rights in Antonio de Brichta University in Madrid, and she's board member of al-Carmel. I'm happy to have you all. I will start with Professor Mikhail Kiryani. His presentation will be about 20 to 25 minutes maximum, and he will talk about the title of the presentation is Voice and Exit in the Israeli System, Millet System. تفضل أستاذ مخيل.
No. Thank you. It's a bit odd to talk in English in Nazareth, but I was one of the people in the organization of this conference to insist that we should have at least one session in English because it opens up what we're discussing to the whole world instead of just being something that might be local. And since the issues that we will be discussing are issues of concern not only for us but for others as well, so I think it's possible to have something in English. But then, as we said in the discussion in the Q&A, we can turn into Arabic, to Hebrew, whatever, but at least to discuss the topics in English, I think that would be helpful. So we'll see how it goes. Okay. So what I'm interested in is the interdependency between what we call voice and exit. Exit is a principle of liberal theory. When we speak of exit, it's to justify why we should have restrictions. In many frameworks that we exist in, we are restricted by the internal organization of that framework. It would restrict our liberty. It would tell us what to do and what not to do. And then we need to justify, if I'm liberal, if I'm autonomous as an individual, why are you restricting my freedom? Okay. So liberalism would say, if it's by consent, then that is okay. That's possible. And actually, ad hoc frameworks, temporal frameworks, or even lasting frameworks would justify internal restrictions by virtue of saying, well, if you don't like it, you can leave. Okay? So at the university, it's full of restrictions. I, as a professor, would determine what would be the course like. You have an exam that you have to take in order to pass. And that exam is regulated by different rules. And it's all about restrictions. And if you sit in class, you should hear me instead of me hearing you. Okay? It's not a democracy. It's restrictive. But then we justify it by means of, if you don't like it, you can leave. You don't have to be here. So consent becomes really the second name of exit. I, as a lawyer, would need to abide by the ethics of the profession. Okay? And this set of rules would kind of restrict how I can deal with certain cases. I can't be in a conflict of interest. Okay? Even though I would say I would do my job in a perfect manner still. But these are the ethics. I have to abide by the rules. I'm not at liberty to act otherwise. But then we justify these restrictions by virtue of me being able to leave the organization, to leave the structure. Okay. Now, in the sphere of multiculturalism, okay, if we can go back, please go back one slide. Yeah, okay, just a second. So in the sphere of multiculturalism, when we justify why minorities should have an autonomy, and that autonomy would entail, right, restrictions on individuals within that framework, how do we justify these restrictions? We justify these restrictions by the ability of individuals to exit. If you don't like it, just leave it. You can exit. So I'll give you one example that does not have to do anything with us here. But it has to do with Native Americans in the U.S. If we can go to the slide of Martinez, it's here. These are reservations for the Native Americans that exist in Northern America, in the U.S. as well as in Canada. These reservations have a lot of internal restrictions. They regulate their internal affairs as they see fit. That's why you sometimes have casinos in some of these reservations, while it is illegal to have gambling in the state that the reservation exists in. Because they're sovereigns, they can have internal restrictions. And one of the problems of these internal restrictions is that some of these internal restrictions, some of these laws that are made applicable in these reservations happen to be discriminatory against women. It's not equitable. Women are treated differently. So this is one of the cases that came up before the U.S. Supreme Court, where if the woman would be marrying a person outside the tribe, she and her children would not be entitled to medical insurance according to the local regulation of medical insurance. But if a man would be marrying outside the tribe, okay, then he and his wife and his children would be entitled. So it was discriminatory. The question is, can we justify then having these internal restrictions by saying to that woman, if you don't like it, leave it. You can leave your tribe, live elsewhere, and then you would not be restricted anymore by this kind of regulation. The Amish in the U.S., they are also accommodated as a religious minority, okay? The thing that came up in a U.S. Supreme Court decision, and this is the decision, was that the Amish would be taking their children out of school, okay, at the age of 14, whereas mandatory education entails that they should keep their children in schools until the age of 60. And then they were indicted and and then convicted of the crime, and they went up to the Supreme Court saying it's against our freedom of religion if we are not able to indoctrinate our children at home according to our rituals and norms. And then it was a big fuss. But then this is restrictive now on children, not necessarily on women. If a child is taken out of school at an early stage, then it becomes a concern for us as a society whether that child would be getting the appropriate education to handle the complexity of what life entails, okay? But can the child exit the Amish? Can we speak of exit when we are speaking of children? So it becomes an issue. Now, why I'm dealing with exit, and then I would be discussing the issue of voice, because it connects to the Milit system, to the jurisdiction of different religions in Israel, in Palestine, in Jordan, in Lebanon, right? That these religious communities have authority over their individuals, okay, in matters of personal status, family law matters, and as it happens, these laws happens to be discriminatory against women especially, and sometimes even against children, okay? Can we then discuss the legitimacy of having such a regime where you are having this authority over individuals, right? By saying, well, if you don't like it, you can leave it. You can exit the religious community. But then I would be asking, and this is the question I would want to ask, in the Israeli reality, exit where? Okay. Because for exit to exist, you need to have a sphere to which you can exit to. Okay? So exit is not just about my power, okay, to leave my group, but there needs to be a receptive sphere into which I can belong, I can become part of. Now in the US, if I don't like the Amish community, and actually the Amish community is shrinking, and the Native American community is shrinking, right? They can leave their community, okay? Or they can leave their tribe and live somewhere else, and they can become just like any other American. Try at least, it's possible. There is a sphere to which you can exit to. And the question, at least in the Israeli scenery, and in many other places, maybe not necessarily still the same, is there a receptive sphere to which I can exit to? My claim is that it's a limited sphere of exit. I will discuss some of the issues that would be showing that there might be an exiting route, okay? But it's not really complete, it's partial, it's limited, and therefore we have a predicament, we have a problem in justifying from a liberal theory whether we can have this restrictive authority on part of religions that would be mandating our own liberty when it comes to marriage and divorce, and sometimes even other issues as well. Okay, so this is the thesis. Now, what is the interdependency between voice and exit? Now, I just spoke about exit, of protecting me. And this is what I've been discussing so far. Okay, still have some 20 minutes, right? Okay. Okay. Now, I've been discussing the issue of exit as having a protective role, which is number 2, okay? It's protecting me from the internal restrictions. So I don't like it, I'm leaving it, I'm exiting my framework, okay? Now there's another role of exit, it's called the transformative function. And this has to do with a bit of economics. It's very simple. When we had Basic, right, as the sole phone company with a monopoly over phone services, I would be calling Basic all day long, shouting, the services that you're providing is really below average, if it exists, right? And nobody would be hearing me. My voice would be minimal in terms of its effect on mobilizing some change within. But when there is a competitor for Basic, I can say, Basic, listen, I don't like you. I can go and search some other service provider. I can exit. Then the mere possibility of me exiting, seeking the service of a competitor, would make my voice empowered within Basic. Then Basic, that corporation, would wanna treat me better, because if I'm not satisfied with the services, I can just leave and go elsewhere. So exiting the framework empowers me within, even if I don't exit, because the mere possibility of exiting, okay, would kind of incentivize the service provider to do better. Okay. The question is, if I would be able now to point to some exiting routes from our millet system, if I can leave my community in one mode or another, is that transforming the religious structure from within? Is there a transformative function of exit if I can really exit my religious community, okay? I would say, listen, I don't like the Greek Orthodox jurisdiction over my marriage and divorce. I'm exiting. Maybe I can, okay? I can become maybe a Catholic, but it turns out that the better route is the other way around. Anyway, but that's okay. Or I can become a Muslim, I can become a Druze, I cannot become. There is no conversion into the Druze religion. That's very interesting, right? That's very interesting. Okay, I can leave my religion, I can become part of another religion. Is that exit? I'm not sure, okay? So is this power of me leaving my community would have a transformative force. It would be empowering my voice from within. Actually, we do have some evidence, and Irene had a comprehensive study on this transformative function of voice and exit. In 2001, the law was amended granting Christian and Muslim women the possibility of filing their alimony claims before the civil family courts instead of the religious courts having exclusive jurisdiction over alimony claims. So the woman now can choose between whether going to the Sharia or to the church court, the Christian court, to file her alimony claim, or going to the civil court. Now, once this happened, and we have evidence proving it, so the mere fact of me as a woman exiting my community, at least when it comes to alimony claims, now going to the civil courts, we have even testimonies by qadis saying that we have improved the level of our services when it comes to dealing with such alimony claims. The level of payments that now we are granting, right, are higher. We have evidence. So we can see that once there is more exit, and this is one possibility of exit, then there was a transformative kind of evolution where the conduct of the religious courts have become better, at least when it comes to alimony. Now, there is one mode of exit that I want to discuss, and it deals with private international law. I don't want to get you into the specifics. It's a bit, yeah, that's fine, okay. Now, one of the exiting routes that did prove to be effective is that I go abroad, okay. I don't need to get married in Israel, where marriage is mandated by religious jurisdiction. If I belong, there is no civil marriage in Israel. I guess this is known, right? So there is no civil marriage. But if it's a mixed marriage, okay, or sometimes people would be exiting out of protest. I don't like religion. I'm an atheist. It does happen more actually within the Jewish community. I don't like rabbinical jurisdiction. I'm going to Cyprus, even though both parties are Jews and they have no problem getting married in Israel. But they're going to Cyprus out of protest, okay? It's not even out of protection, because people can live with each other irrespective if they're married or not. But nonetheless, they're going, having a marriage, celebrating a civil marriage, and then they come back. Now, there has been a very important evolution in terms of Israeli law when it comes to marriages that were concluded and solemnized in somewhere other than Israel, when the Supreme Court, okay, would then be recognizing this kind of marriage. And this evolution, I think it's important in discussing this issue of religious jurisdiction and the problem of exit. But then what I would be heading to is whether this evolution is having this transformative function. Is it really changing the internal structure? I think it is not. But it is happening. So this is a list of cases where the Supreme Court would be saying, if you had a marriage certificate that has been issued by the country in which you got married, and it's a civil marriage, and you come to Israel and you ask the Interior Ministry to register you as a married couple, then that official would have to register you as a married couple, and he would not, or she would not be asking questions about whether you could have gotten married or not, and your status would be registered, okay? And then it was kind of stretched to same-sex marriage in Israel, okay? You get married as a same-sex couple somewhere else, and then you would be registered, and that was possible. And another issue was whether this is really bulletproof. It's not, because of two reasons. One, if both couples, okay, would be from the same religious community and they want to come back and then they would want to get divorced, they can't go back to Cyprus and get divorced under Israeli law. their divorce would need to take place here. And it would need to take place before the religious community. So you're in a better shape if you have a mixed marriage and you get married abroad. When it's a mixed couple, they belong to different religious communities, then they would come back, want to get a divorce, but there is no court that would have jurisdiction, because any court, religious court, would have jurisdiction conditioned on that both parties would be belonging to that community. A Christian court cannot deal with a marriage between a couple that one is a Muslim and one is a Christian. Okay? Even a Christian court cannot be dealing with a couple if it's a Greek Orthodox court when one of the spouses is a Greek Orthodox and the other is a Catholic. Each of the religious communities among the Christians is a separate religion. To become a Catholic, even if you're Greek Orthodox, you would have to convert. And the procedure is just the same as if you were Muslim converting into Greek Orthodox. It's amazing. Anyway, what I'm trying to say is that this exit is possible, but it's partial, and that's why it's limited and has not really transformed, okay, the law from within. The second reason I think why we are not witnessing any transformative kind of a process within the religious communities to improve. I'm losing people. They're going to Cyprus. I need to improve. Actually, there has been some talk on this topic in Lebanon in the early 2000s. Okay, Ilyas Harawi did initiate a civil marriage in Lebanon. And one of the issues that he came up claiming, saying, listen, these Lebanese are going to Cyprus. Shouldn't we be affording these Lebanese a solution in Lebanon? Okay. It didn't culminate into a law, but there was such an initiative. The reason I think why it's not been translated into a voice of a transformative among the Palestinians inside of Israel, A, because of the fact that people from the same religious community are not protesting. They're not going out of protest. So the religious community is not really losing its customers. So if I'm not losing customers, why should I improve? That's one thing. However, and this kind of makes an introduction to, I think, what Sonia has been dealing with, even if she's not been speaking about it, where there is some evidence of this exiting, having this empowerment within the religious communities among some of the Christian communities. The Greek Orthodox community does enable couple to get divorced. So if I'm Catholic and I'm married and I'm stuck with the marriage and it's a broken marriage, it does happen that these Catholic couples are converting, becoming Greek Orthodox, then paying some enormous sums, sometimes above the table. I wouldn't say anything under the table. But it's considered to be fees, but fees in the thousands of shekels. This is crazy, right? They're paying extraordinary fees, okay, for getting the divorce. So people are converting, and as it happens, the Catholic community did have a major reform in terms of the personal status. Annulling a marriage among the Catholics has become more and more possible now than it was before. So we are seeing that there is sometimes this interdependency between exit and voice. I would only conclude with this statement. Exit can sometimes be elusive, and I think what I was trying to say all throughout is that for exit to happen, it cannot just be theoretical. It needs to be viable, okay? We can't speak of really people leaving a framework if it's not a viable option. Only when it is viable, it might have this transformative. So we need to make a distinction when we discuss exit, whether me leaving the framework is really a viable option, because if it's not, we can speak of exit, it's only theoretical, but it wouldn't have any force of empowering or changing or transforming the internal structure of the community. So I'll leave it here, and we can discuss some of the issues maybe later on. Thank you.
By the program, I think.
Okay, you don't. Okay. Yeah, I don't see the program. Do you have it? Very good. Okay, very good. So yeah. So now we will have Sonia's presentation, Dr. Sonia Boulos' presentation. It will be about citizenship, status, family, and due process, the case of the Christian courts in Israel. Actually, the word is not Christian court, but I can't pronounce it, so you will correct it. It's difficult. It's very difficult for me. Yeah, so my mother tongue is Arabic, so it's difficult for me. Anyways, I just wanna, and let me Mkhail be proud and excited when I talk now, because when I speak now, because we're talking about Sonia will present a research that was initiated by the Gender Studies program at al-Carmel. She wrote it with the advocate Shireen Batchoun. She will be with us tomorrow. I don't see her now, but she will be tomorrow. And we worked on this research, so we were very excited to present it here. We presented it before internally, and now we would like very much to hear your comments on this research. And I would like to thank actually the International Christian Committee in Nazareth, جمعية المسيحية العالمية, for the support and the cooperation in establishing this research. تفضلي سونيا.
Thank you. No, I'm fine. Well, I'm trying to be as brief as possible, because the research we did is basically on the right to fair trial, and it's a right that is, sharing with you the results of our research. I want just to say a comment, which is like the background of how we started this research. But before that, I'm going to quote Professor Karyani here, that within the literature, the Palestinian literature on family law regime in Israel, I think it's very, we all agree that we fully understand what is the role of the family law regime in Israel, which is basically to fragment the Palestinian identity and convert Palestinians into Christians, Druze, and Muslims. That's one aim. By this, you lower the cost of control of the Palestinian community in Israel by making them religious community. And at the same time, the role of this regime is to make sure that Jewish citizens are not, it's difficult for them to marry someone outside their community. So based on that, the literature that exists on religious courts in the Palestinian community focuses almost exclusively on Sharia courts. Much less exists on ecclesiastical courts, and whatever exists focuses on substantive issues such as gender equality, adoption, things like that. Almost no one talks about the right to fair trial. And I think this was one of my critiques of as a member of the working group on equality in personal status laws, when we were working about substantive issues like gender equality, saying, but what about the right to fair trial? These small details are not, useless. They make sure that a judge has a limited discretion, that a judge is treating everyone equally, and so many other things. So we decided, like Shireen actually wrote a position paper when she was working at Kayan that exposed some of the issues, that the lack of any procedural rules governing the work of church courts. So the question was, to what extent do these courts comply with international standards on the right to a fair trial? How did we conduct our research? We identified leading lawyers who work in the field, who appear regularly in courts, and we conducted in-depth interviews with them to try to understand the dynamics of ecclesiastical courts in Israel. We're talking about 12 lawyers from different parts of the country, and we have also representatives of from Jerusalem and Ramallah because they have extraterritorial jurisdiction. Now, Some people may think that 12 lawyers is not a big number, but in fact, access to courts is so limited that in relation to Latin courts, only 7 or 8 lawyers are allowed to appear. So that's a lot of lawyers compared to, to those who work. Now, we use international law because it reflects the hardcore of the right to a fair trial. So basically, the basic article is Article 14 of the International Covenant on Civil and Political Rights, which states that all persons shall be equal before the courts and tribunals in the determination of his rights and obligations in surat law. Everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. What does it mean, a court established by law? It means that not only that the law decides what kind of cases a court can hear, it also means that all the central aspects of the functioning of the court must be established by law, including procedural norms, the laws that regulate the appointment of judges. All these aspects must be established by law. The procedural aspects are so important. For example, the European Court of Human Rights made it very clear. That's not a matter of technicality. It's a matter of making sure that the judge is fair to everyone, that judges have limited discretion. What did we find in our... there is no law whatsoever. There's no law whatsoever that regulate the functioning of those courts. Even the High Court of Justice describes this situation as extraordinary situation, and I'm quoting, "This is an extraordinary situation. There is a judicial system whose judgments have binding force in the State of Israel. Nevertheless, the legislature did not regulate, even at the most basic level, the mode of operation of this system, neither from the organizational aspect nor from the functional aspect." So what do we find now on the ground? In relation to Catholic courts, they use canon law. There's the Western version of canon law and the Eastern version of canon law. This is a law that is, was adopted by the Catholic Church. It's not an official law in Israel. It was not incorporated into the system through an act of parliament. So they apply supposedly this law even in procedural matters. However, our interviews reveal I speak fast. Okay. So what did our interviews reveal? I'm okay. Okay. Can I continue? So basically, what we found in our interviews, that lawyers said clearly, we don't understand, we have no knowledge at all of the procedural aspect of canon law. We cannot access it, we don't know how it functions. And they also told us that even judges don't understand how canon law functions in the procedural aspect. I'm going to Joe, this is an excerpt from an interview. This is what one of the lawyers said. Here in the country, we don't have much knowledge on religious procedural law. Lawyers who work in the field don't have it. They don't have tools and knowledge. Not because they don't understand things, but simply because there is no place to study. When I go to conferences on canon law abroad and meet lawyers there, you can see they have books, resources. There are Catholic universities that teach canon law. They study these issues for 4 years. But here we don't study these issues. Another interesting quote, I'm not going to quote much, that a lawyer told us, you think that judges understand canon law? I'm telling you, not even judges understand canon law. They don't have education in canon law. So what does this mean? This means that we never met any lawyer who said that he or she appealed a decision based on procedural grounds, because you cannot appeal something you don't know, you don't understand, you're not familiar with. In the Greek Orthodox churches, they don't have anything. So sometimes they use, the civil law applicable in civil courts, but other times no. So they don't have a consistent practice. Which means In one case, they can give you 30 days to appeal. In another case, they can give you 45 days to appeal. So you don't know. This is what a lawyer said. I'm stuck now with... As a lawyer, I prepare my clients from the beginning. We are in a court that lacks clear procedures. We have to be prepared to see the other party not serving us correctly or playing with us. And we know it, but we have to be prepared that even if we ask in an unyielding way to be granted proper treatment, it's not guaranteed that the Orthodox court will respond. Competent tribunal, one central element, which is, absolute component of the right to fair trial. Competent means that judges must be competent. They must know the law, because you cannot be judge if you don't know the law, not to talk about the moral, characteristics of the judge. So what did we find? You don't have to have a legal degree to be a judge. You don't have to have training in Israeli law to be a judge. Catholic courts rely on canon law, which, according to canon law, you have to have at least degree in canon law. But here, they don't ask a degree in canon law. You have to study theology. Theology and canon law are not the same. And if you study theology, that doesn't mean that you understand canon law. In the Greek Orthodox Church, you just have to be a priest. You don't have to do anything else. What did we find? Now, although churches, ecclesiastical courts don't hear a lot of cases beyond marriage and divorce, but technically speaking, they can hear cases on custody, on other things. So the fact that the judges have zero knowledge of Israeli law seriously contradicts international law. Another issue interesting that we found, that in the Greek Orthodox Church, judges don't speak Arabic. So I don't know how someone can be a judge in a court without knowing the official working language of the court. So that raises serious issues in terms of the right to a fair trial. Independent tribunal. Independence means that judges must be independent from the government, from the executive branch, but also independent internally from the institutions of the judiciary. So what happens on the ground? Churches appoint judges without any kind of monitoring from anyone. The state cannot interfere, the public cannot interfere, so they fully control the procedure of appointing judges, and we don't know how they do it. They also pay the judges, but they don't pay them for being judges. They pay them for being priests, which means a priest has a lot of functions: teaching in a school, having his own parish, I don't know in what town, and on top of that, on Thursday, he gets to be a judge. So they don't get money for their work as judges. And this is absolute, from an international law perspective, I can't even begin to explain what this means. Another issue that, is serious, in our opinion, is that the church, asked judges to act as priests. So when someone is sitting in the court, they don't perceive themselves as a judge. They perceive themselves as a priest. So they think their judicial functions are continuation of their pastoral duties. So that's why for them procedures and stuff like that is irrelevant. They perceive their role not to decide a dispute based on the law, but simply just to try, to fix issues. What else did we, So if you think of the situation, you're appointed by the church without any kind of scrutiny. You get paid by the church. You're employed. Everything you do is related to the church. It's very hard to think that judge sitting in, any court can be independent. Now, impartial. That also is a serious issue. Judges must be impartial. A judge cannot have preconceptions about a case, cannot have bias in one case. But what happens, in fact, that we met, most of the lawyers we met told us that in many cases they dealt with, one of the priests sitting as a judge was involved in the dispute between the couples before they got to the court. So you have a judge hearing a separation or divorce case when he knew 5 years ago that these people are having a trouble. So maybe he was part of the trouble. So just one quote. When we asked one of the priests that we interviewed, but what do you do if you sit as a judge in a case where you were involved, as a priest? He didn't understand the question. And he told, well, all the private, intimate details that I know, I keep to myself. I don't tell other judges. If they want to tell the other judges, so he even didn't understand the question. How can you sit as a judge and pretend to have no bias when you were involved from the beginning? Okay, going to skip. Fairness of the hearing. Here must be a fair hearing. A little bit more. Don't discriminate. You give him more.
I'm a minority here.
No. Men are never minority. Anyways. So, the fairness of the hearing. So, one of the basic elements of the fairness of the hearing is that, the parties should have the right to question all the evidence, all the witnesses, try to explain their own version of the facts. So what happens, at least in Catholic courts, because they use inquisitorial systems, that they cannot do that, lawyers. What lawyers are allowed to do is to send a list of questions to the judges. A lawyer cannot ask directly. And the judge decide if he's going to allow the question or not. Usually they allow all the questions. But sometimes they decide to remove 2 questions, change the order of questions, and lawyers were telling, they interfere my strategy. If I put an order for the question, I know why I need to ask question number 1 before question number 5. You come and you decide to remove 3 and start with 5. You completely, miss my strategy. Look, since we don't have enough time, just to summarize, you can see in more details everything we worked on. There is absolute disregard of the right to a fair trial in those courts. So when we finished going to skip to the end. When we finished the research and we were representing the outcomes in an internal meeting, and Professor Kariani was there, and he just said, look, it's a violation of, how did you say? Alif, Bet, the ABC. There's no right to fair trial. It's like unbelievable. So, and then after these comments, I went back and I was talking to Shireen. I told her, Shireen, there's something much deeper going on here. We have to understand what is, it's not normal. I fully agree with the analysis that Israel uses a religious family law regime to fragment the identity of Palestinians. But you can achieve this goal and guarantee a minimal, kind of protection of the right to a fair trial. We will continue to be Christian, Druze, and Muslims, but with a little bit of the right to fair. There's something deeper that is going on here, and we have to ask ourselves the question, why? And I think reading a bit about the experience of Native Americans, and I'm glad that you brought the case of Martinez versus Santa Clara Pueblo. Historically, the right to a fair trial was connected to citizenship. Those who lacked citizenship status did not have the right to a due process. Things started changing, but also belonging to the nation is some sort of continuum. The more that you are perceived as the part of the hardcore of the nation, you have more protections. If you are perceived as a foreigner and not an insider, you don't have due process protections. A perfect example would be the situation of Native Americans in the United States. Native Americans were given, like all of them, citizenship only in 1924. Only in 1924, all Native Americans became U.S. citizens. Before that, many Native Americans were not considered U.S. citizens. The U.S. Bill of Rights does not apply to Native Americans living in reservations. The U.S. Constitution excludes Native Americans who live in reservations from the protection of the Constitution. In 1968, the Congress decided to enact the Indian Civil Rights Act. They tried to close the gap, but even then, the due process guarantees were much lower compared to the U.S. Constitution. In Martinez versus Santa Clara Pueblo, when she used this law to say they are not protecting my constitutional right as U.S. citizen, she went to a federal court, a court outside her community, against the tribal court that did not give her children membership. The federal court says, no, we're not going to help you. We're not going to interfere. Only in cases of habeas corpus, like related to liberty, we might interfere. But that's your problem. Go back. Now, if we read the history of the relationship between the U.S. and Native Americans, it's a history of creating them as aliens all the time. They are citizens and aliens at the same time. These small islands of autonomy simply reproduce Native Americans as aliens, not as full citizens. Even those who hailed the decision of Santa Clara, saying that, yes, this is the correct decision, but because tribes should decide their own membership rules, I fully agree with Mamdani, who says this is completely the wrong understanding of the situation, because what you are enforcing is not customary law. It's not indigenous norms. You are enforcing settler notions of group membership. Indigenous communities never thought about blood tests to decide who is indigenous. This is a white notion of membership. So don't say, this is, I think his quote, this is colonial paternalism in the language of self-determination. Coming back to the Palestinian citizens in Israel, yes. Coming back to the Palestinian citizens, a lot has been, not a lot, but Palestinians who wrote about this, I see some of them are here, they describe the citizenship as, settler colonial citizenship, empty citizenship. Tatur argues that the aim of the citizenship regime in Israel is to produce Palestinians as foreigners to their own homeland. Azmi Bishara talks about incidental citizenship, that we are just guests that are tolerated. So that's why we don't have any sorts of protection to our due process rights, because we're not even perceived as full citizens. So that's why we don't get these kinds of protections, especially in areas in which we are recreated as foreigners. I believe that the family law regime in Israel not only fragments the identity of the Palestinians, but it also, by saying that it's okay for, one fact, just I skipped. You know that the Maronite courts, if you want to appeal, the court is in Lebanon. You have to appeal a decision in a court that sits in a country that Israel defines as an enemy state, and you cannot go there physically. And there was a case in the Supreme Court. There was a case in the Supreme Court where someone said, this is violation of my right to due process. How can I appeal a decision in Lebanon? And the Supreme Court refused to interfere, and they found a way to get out of it. So I believe part of what is happening is that the family law regime create us as members of extraterritorial religious communities. That we can belong to Lebanon, to, I don't know, in a way that blurs our native status. And it resonates with Netanyahu's speech. Arab citizens have 22 nations around them, so they don't need another. So it creates us as some people who belong to somewhere else. And the best exemplification of Palestinians being created as foreigners is the nation-state law that excludes us from the right to self-determination. That's how we are made foreigners. That's why due process guarantees do not apply to us in this context. One final thing, and I finish. you might ask yourself a question, okay, but why the state interferes more in Sharia courts? They appointed judges, they have certain regulations to deal with the procedural aspects of Sharia courts. I think one of the things we learned from this subject that we have to, although we don't want to recreate the categories that Israel creates, but there is a difference between the way control mechanisms function even among Palestinian communities. And I think because the Christian Palestinians are viewed as less threatening to the state is willing to give them more space to become foreign and go to Lebanon and Rome. No, but I think it's more than just wanting to please in the Vatican. I think it goes deeper in the sense that no. Okay, we continue to talk about this in the time for questions, but I think it's worth taking into consideration that sometimes the state operates in a different way when it deals with some sections of the Palestinian minority, and we shouldn't be afraid to recognize that, because we're afraid to recreate these categories of Muslims, Jews, and whatever. Thank you.
Just one sentence. شكرا كثير سونيا. Yeah, I just want to ask you a question, and later on we will not question actually. I want to understand. Let's say some of the women in the Christian court, I will say Christian, wants to exit and have the right to civil marriage. Other women want to be part of their community and the religious community. I mean, whether Christian church or Sharia courts, but they want it to be better. You just talked about the only option of not exiting by like competition, have the right to exit, so I threaten with my right to exit, so the competition would make these churches better or these courts. And we saw it in the Sharia courts according to Nahida's research. I don't see Nahida here. But you didn't talk about the option, or maybe you will, that I want to be part of my community, religious, cultural, whatever, but I want to be part of the change, not by threatening them, but by having my democratic right of being part of the change. Like, to talk about this more. Okay, Ayelet will talk about protecting the women or protecting the state, polygamy and ontological security in Israel. تفضلي.
Let's try to put it here. Do you hear me if it's in the glass? And then I don't need to hold it? You said 2025, so I'll be. No, I'm good. I'll be fine, I think. And first of all,
I can move the slides.
yeah. This is why I put it here. So I hope I can handle this. I have to say I'm very, very, very excited to be here in this annual conference, and I appreciate the option to speak in English and simultaneous translation. I really appreciate it. I'm so grateful for the invitation, both from Arin, Mikhail, and Naila. And what you cannot hear me. I'll drink it. Okay, I have no choice. I'm sorry. So I just said thank you so much, and I'm excited to be here. The research that I will present today is based on a research by Professor Becky Cook and myself. And what we're dealing with basically is how democratic states and procedural democratic states address the issue of gender violence towards minority women, and how they assume to guarantee the protection of these women, looking mainly at the level of rhetoric and discourse. Empirically, our case study involved an analysis of government policy and rhetoric towards the practice of polygamy among Bedouin minority within Israel. And we used that case as a platform to arrive at some generalized thoughts regarding the relationship between government and perceptions of security, ethno-national hierarchies, and gender. In addition, we listened to the various voices of polygamous women and hear their life stories. And we base our discussion on the theoretical concept of ontological security, arguing that often states confront issues of gender violence through this specific theoretical security-oriented framework. Now, the background regarding our case study is, I think, known to all, that polygamy is prohibited in Israel, although it is practiced, and we can all read both Michael and Sonia and Rawia's writings here as well regarding this practice. And I will briefly mention that despite the legal prohibition over the years, the government has systematically failed to enforce the law. And the government has its own reasons to do that. Now, I have to admit that a slight change in the attitude of the states towards polygamy occurred in 2017 under the leadership of Netanyahu's previous right-wing government that is now, like, it looks moderate now, right? It's like now, like, God will help us from this one, or I don't know who. But what was changed was the establishment of an inter-ministerial task force to make recommendation from combating the practice. Now, with the publication of its wide-ranging report in 2018, reference to polygamy began to permeate official political discourse and became a common reference to discussions related to Arab-Palestinian Bedouin minority. And this course included the need for the protection of Bedouin women. The government, the Israeli government, was initiating these discussions, at least by rhetoric, in order to protect the women. Yeah, I will reach that, of course. So now we would like to look at this discourse critically, okay, in order to look at how the states formulate her own perspective about, or its own perspective about protection of Bedouin women from violence as a part of a wider discussion of identity, gender, and identification with the Israeli state. Now, thinking about this discourse brought us to try to understand the ways that the state was framing the discussion of women and violence, and how these political and public framings differed from the framing and context presented by the women themselves. Now, we are using here a term called ontological security that was phrased by a psychiatrist named Lang, and he is one of the main originators of the concept, and he's describing the ontologically secure agent as someone who has a sense of his presence in the world as a real, alive, whole, and in temporal sense, a continuous person. And while its absence, it renders the ordinary circumstances of everyday life constituting a continual and deadly threat. So that term was initiated in by psychiatrists and psychologists, and it moved then to sociology, and then move again and shift to political science. And in the context of political science research, which is our field of expertise, this perspective of ontological security suggests that state and state actors, like the government and politicians, will act to provide ontological security in addition to physical security, and thus will act in ways that contribute to a stable sense of the collective self among its citizens. The provision of ontological security by the state is often bolstered by the use of narratives that highlight the insecure dread and anxiety that result from lack of security. And that was exactly the case of what the right-wing government was doing with the issue of polygamy, of how dangerous it is, how harmful it is. Okay. Le'at. Okay. Slowly. Sure. So, a growing body of research focuses on the gender assumptions underlying issues of ontological security. And gender readings of ontological security look at the role played by notions of home, fertility and the nation, and also an idea of nation as family, in addition to, of course, the role of women. Now, what is really interesting here is that the reality of minority Muslim women globally, in a case in point, in that they are often referred to by states in the context of ontological security and have been targeted both as object of state protection and simultaneously as the embodiment of a threat to the state. They are both, they need the state's protection, and they are both very, very dangerous. Now, I want to move on and to introduce some perspectives of women discussing the reality of being in a polygamous marriage, and we both held some personal interviews, so we have also primary research, and also we're based on secondary research by Abu Sareb that was kind enough to share our findings with us. And what we heard is that the opinions regarding the practice of polygamy varies by across age group, gender, of course, and even within those who practice it. Furthermore, perspective of polygamy. Okay. Sure. Okay, so I'll be slower. Okay. And so I was saying that the perspectives varied. Overall, we can say in general that most interviews that we held shared perspectives about a deep sense of existential insecurity and isolation, uncertainty about their self-identity and belonging, sometimes physical violence, and very troubling stories. So if I would like to, and you can read here one of the interviews that we held, but if we want to look from the perspective of the women, many shared that they felt unaccepted by their communities, they lost their status and their tribe, their ontological insecurity is evident and striking, and they often feel humiliated and in both emotional pain and physical pain. So this is in terms of the women themselves. Now when we move to the state's perspective, we hear a different story. We have like the heroes that are here to rescue the Muslim women or the Bedouin women in Israel. So if we look at Israel's campaign against polygamy, it could be read as a chapter in the master narrative of its ontological security. And in its spirit, a chapter that highlights a gender element. And the polygamy campaign by Netanyahu and by Shaked and by Smotrich and Ardan and others tells a story regarding the essence of Israel identity and about who belong and who does not. And I think more significantly, the polygamy campaign presents gender identity as an explicit and central actor in this narrative. So we can hear, I don't know if we want to talk about him, but nevertheless, I think it's important to see, let's see Gilad Ardan. So he's saying, polygamy among the Bedouin, and in particular when we talk about a Palestinian woman, is a crazy and dangerous phenomena that we are obligated to eliminate by any means available. Children who grow up here and who are influenced by Palestinian incitement can eventually be tools in the hands of terror organizations and threaten the demography of and our governmentability of the Negev and beyond. Not only is the despicable polygamy harmful to women and children, but it is a real security threat. So you could see it on the table, Erdan's perspective. He is considered to be moderate, I don't know. And we can have Netanyahu, of course we want to hear about him more, right? So a quote by Netanyahu, which is more concealed and more sophisticated, let's say. So he's saying polygamy is not a social and economic phenomena. It is first and foremost illegal. It is harmful to the status of women. In addition, disrupts the demographic balance in Israel. And of course, who doesn't want to hear about Smotrich today? So the birth rate among Israel Bedouin community is a bomb. And that must be handled. And if we don't refuse it, it will blow up on us much stronger. They double themselves every 12 years. And so it's something that needs handling. The more you modernize them, the less children they have. Okay? So this is the previous right-wing government, not today's. I don't want to know exactly. Okay, let's move on. So what I'm saying here, that we can see the incredible difference between the stories of the women themselves about their own realities in polygamous marriages, the problems they tackle with, their aspirations, their challenges, and what they want to do. And on the other hand, we see the government and how the government portrays the issue of polygamy and the danger of polygamy. And I would like to be kind with the timing. So I will just close this discussion with 3 conclusions that we have from the current research. And I think that polygamy for a vast majority of the women involved, if we look about the individual level, it constitutes a significant breakdown in their sense of ontological security. In those meanings of the psychiatrists and psychologists, it breaks down their sense of ontological security. It brings them to ontological insecurity. And also when we talk about with women who are not a part of polygamous marriages, they're afraid that their husband will take another wife, and they are seriously concerned and troubled about that. So I think that the lives of polygamous women were narrated as humiliating and troubling. And in some sense, the local community that should normally provide integrity, it's not always happening. And the sense of ontological insecurity is very much associated with polygamy in terms of the women themselves. So I think that this is in part of the women themselves. Now when we move to a different level, to the extent that states are ontological security-seeking actors, the process whereby states define their ontological security needs to become they need a particular way of defining the sense of state distinctiveness and national identity. So what the state is doing, that the narratives of government leaders and government report itself, polygamy is presented as the real and immediate threat to the fundamental components of the Israeli identity, and hence also a threat to the existence of a stable cognitive environment. So I think that in that sense, the state enforces distinctions between the majority and the minority. We don't act like this. This is what they do, and they are very dangerous to us, and the women are a part of it. And now the third element that I would like to mention, and I will close with that, related to the gender aspect of it. And I think that issues related to fertility, demography, and the home related to gender understanding of security and insecurity, and they are central to the rhetoric of ontological security. Women, as guardians of the home and the protectors of the family, will therefore always implicitly figure in these narratives as the commitment to protect women's right on the one hand and to prevent violence against women. It's a part of the discussion of ontological security. But at the same time, those women that the state allegedly want to protect are being the real danger of the society, of the narrative about the Israeli society and the democratic and Jewish state. And finally, within this narrative, gender is employed both as a central organizing trope and also as a strategic political mechanism. The need to modernize Bedouin society by eradicating the so-called patriarchal and abusive practice of polygamy is used not only as a trope, but actually as a strategic political mechanism aimed as establishing Israeli political power and pushing away the women and their rights. Thank you so much for your attention.
Thank you, Ayelet. I just want to say that Ayelet's presentation is built on a paper that she just published in Politica, the Journal of Political Science of the Hebrew University, if I'm not mistaken, right? So
I have the English version and Hebrew version, and we're working on Arabic version.
Oh, this is nice. Hello, Mabruk. I just also want to add that women as object of women's bodies and women as object of the demographic discourse is not only by the Jewish and the Jewish so-called national discourse. It's also used by the so-called Islamic and so-called national discourse here. We hear it from Islamic leader, and we heard it from national leader. Al-Qaddafi once said that Palestinians should have 2 women in order to keep 2 wives and in order to keep the numbers of the Palestinians. طيب احنا بنفتح للنقاش، وانا بدي ادعيكم تحكوا باللغه اللي بتحبوها عشان كمان بنفع نسمع عربي شوي والترجمه تكون انجليزي، فكيف بتحسوا مرتاحين تفضلوا. تفضلي بليز. هو سامع. اوكي. لا انا فكرت برضو الفيسبوك بطلت اميز لايش احنا محتاجين.
Thank you very much for your presentations. It's always, it takes my breath away always when I'm listening to the status of Palestinian women or any women all over the world. And this was just another panel that just stopped my breathing. With all this and your description of the nuances and all the different levels of trouble that we're in, is there any, how would you address agency, women's agency within that? I mean, I think exit is part of agency. I'm so sorry, I missed the beginning part. Traffic was horrible, but exit is a kind of agency, I think, but I mean something more than that. So that's my question about women's agency.
I would like to speak in Arabic because it's more easy for me to think about some points. يعني ما بين ادعاء بروفيسور كرياني بأنه المجتمع لا يحتاج ليحصل تغيير ما، وبين ادعاء دكتور بولس بأنه إسرائيل تريد أن تحافظ على هذه المنظومة من أجل تطييف المجتمع وتفتيت هويته، من هدول الادعاءين بعتقد في مكان إن كمجتمع نفحص هذا الحقل مين صاحب المصلحة فيه. بروفيسور كريم يتحدث عن بعض الدوافع الاقتصادية، لكن مش بعض الدوافع الاقتصادية، لكن مسألة إنه في أرباح معينة عم بتصير من وراء ضمن هاي المؤسسات. السؤال خارج نطاق السياق الاستعماري، في أماكن شبيهة في العالم. بصفي مسألة الهوية هي قد تكون أقل إلحاحا، لكن هناك السؤال أيضا كيف يحتج الناس ولماذا لا يحتجون. بالتالي في مسألة اللي هي بتحتم علينا نفحصها، بعتقد إنه بإسرائيل أو من دون إسرائيل، رغم إنه هذا سؤال افتراضي، مصلحة من أن يبقى الأمر على هذا النحو من ناحية حتى البيروقراطية الاقتصادية. هاي مسألة. المسألة الثانية، إذا بدنا إحنا نخطو خطوة المسألة الثانية اللي هي بعتقد بحاجة ممكن لتفكير، وإذا إحنا بدنا نروح خطوة لقدام باتجاه حقوق الإنسان والمواطن، وأيضا بالاتجاه الليبرالي، الحديث أصلا عن كل مؤسسة الزواج في السياق دولة الحداثة القومية، اللي هو كمؤسسة ضابطة للمجتمع، مصادرة لحريات الأفراد فيها كل مؤسسة الزواج. يعني كان في هون حديث، وأصلا مسألة من يحكم مفردات وقوى هاي المؤسسة اللي هي غالبيتهم العظمى من الذكور أصلا، فبالتالي في مراكمة لعنف رمزي ورأس مال وقوة ونفوذ اللي هي مسيطر على هاي المؤسسة، اللي أيضا كمان مرتبطة بمراكز القوى اللي هي لها علاقة بالمستوى الحكومي أو الدولي. فبالتالي التفكير بكل مؤسسة الزواج اليوم وأشكالها والبدائل والخيارات الممكنة فيها، بالإضافة لمسألة إنه هل أنا بحق لي أزوج من خارج طائفته أو غير طائفته، هناك سؤال جوهري قبل، اللي هو حتى في مرات إحنا بنصير نضحك، بس في مجتمعات اللي هي من محل مرجعياتها الدينية أو الثقافية اللي إحنا بنشوفها بعض الأحيان بنوع من السخرية، اللي هي بتقدم بدائل زي زواج المسيار والمساكنة وزواج المتعة. بالتالي تبدو هاي النماذج أكثر تحررا لو إنه الذكر مش فيها مركز من نماذج ثاني. فهذا
agencies بالعربي. بقدر احكي بالعربي؟ طيب. لا، في عندنا انه نشخص انه احنا موجودين في مشكله وحده. انا حسب رايي هذا خطأ. احنا
شغالي بس لما يحمل صوت
مش عارفه ايش لا
احكي من السماعه. نشوف الوضع القائم انه هو مشكله وحده. انا حسب رايي هذا خطأ. الوضع اللي عندنا احنا موجودين فيه شوي اكثر مركب من ما هو بس انه دولة بدها تسيطر علينا. انا في كتابي اضطريت لهاي سميتها control by accommodation. الظاهرة هاي to control by accommodation، انه احنا الدولة بدها تسيطر علينا، بس بتسيطر علينا بانه بتعطينا نوع من استقلال. الاستقلال هو آلية انه تتحكم فينا، وهذا بفسر بعض الظواهر اللي احنا عم نشوفها control by accommodation. ولكن في كمان احنا ظواهر ثانيه اللي لازم نتطرق الها، وبتصور انت كمان رمزت الها. نظام الملل الموجود في فلسطين، نظام الملل الموجود في الاردن، نظام الملل الموجود في لبنان، نظام الملل الموجود بشكل جزئي كمان في مصر. طب هناك مش موجوده اسرائيل، ليش مش عم بتغير؟ يعني بصيرش انه احنا بس نقول انه هذا سبب، لا، هذا احدى الاسباب، وهذا واضح. بالمؤتمر السنة الماضية وبعد اللي وراء عندي موجودة هون، كيف النظام الإسرائيلي بشكل واضح كان بده يؤسس الملل حتى يحافظ انه يكون في بيناتنا هويات مختلفة، بدل ما انه يكون في عندنا هوية عربية موجودة هون. اللي وراء بعدها موجودة معاي. وكانت مكتوب عليها السودي سيكريت، انه موجود الاشي، التخطيط موجود، ولكن طب في عندنا اعضاء كنيست ومطان استطلاع وعارين بعدها موجود. طب فيش احنا عندنا، انا متاكد انه الخطاب التجمع والجبهه هو خطاب علماني ومش خطاب ديني. شو بمنع انه يتقدم مشروع قانون لزواج مدني عندنا احنا؟ نعم. طيب معناته دقيقة انا معناته يعني اللي بدي اقوله انه مرات في اعتبارات ثانيه اللي بتردع او تمنع، لانه بفهم انا وهذا فسرته في كتابي انه المنظور السياسي العلماني اللي موجود عندنا بخاف من تشقق اللي يجي على حساب النضال الاساسي اللي هو النضال الوطني. ممكن لا، انا بتصور علماني، انا بتصور علماني انه اذا بدنا احنا نثير الجدال العلماني داخليا ونيجي ونتحدى المحاكم الدينيه اللي تكون اختياريه، لا اكراه بالدين يا اخي، لا اكراه بالدين. انا بدي اياه يكون اختياري مش اجباري. انا هذا مشروع اليوم، بس انا متاكد في حاله انه طرح هذا على يد الاحزاب السياسيه راح يكون في شقوق داخليه، راح يكون في ضعف سياسي اللي يجي على حساب النضال الاساسي اللي هو النضال القومي. هذا انا اللي فسرته، هذا التنظير اللي عندي مظبوط. اسرائيل في عندها نوايا، والنوايا هي بتتطابق كثير مع النظرة الكولونيالية الاستعمارية، بس مش هذا السبب الوحيد، ومش هذا هو الدافع الوحيد. اللي كان في دوافع أخرى موجودة اللي هي ناتجة عن بنية موجودة في المجتمع اللي بتحددها مرات السياسية، وشو بدي أكسب وشو بدي أخسر مرات في هاي المفاهيم. هسه قصة الوكالة الايجنسي، انا وسونيا حكينا بالصيف وجربنا نبلش نعمل. لما انا بدي اجي اشكي ضد الكنيسة، هذا السؤال اللي كان عندي، انا بدي اجي عندي ملام على الكنيسة، عندي ملام انه ليش المحاكم الشرعية ليش ما اخذتش الخلع مثلا من مصر؟ تقدر تاخذ الخلع، فيش حدا بيمنع المحاكم الشرعية اليوم تيجي تقول انه احنا هذا الخلع موجود بمصر نحطه. اسرائيل شو بتقول لها اسرائيل؟ محاكم شرعية. انا الروم الارثوذكس، هذا القانون البيزنطي من القرن الرابع عشر انا بدي الغيه، بدي احط قانون جديد محله. شو بتقول لاسرائيل؟ ولا شيء بتقدر، بس مش عم بيصير. بس السؤال الايجنسي اللي هو هذا سؤال باي معنى؟ انا بدي اشتري، عندي الملام، لمين بتوجه؟ مين العنوان تبعي حتى الوم المؤسسات الدينيه؟ عضو الكنيسة، الكنيسة، ولا المحاكم الشرعية، الخور المحلي؟ مين الوكيل تبعي انا للتغيير في الآليات الدينية الموجودة؟ انا حسب رأيي هاي كمان معضلة، هذا كمان مشكلة موجودة عندنا، فيش عندنا عنوان واضح. لمين بدها تتوجه؟ لمين بدها تتوجه؟ بدها تتوجه لعايدة، بدها تتوجه لحنين، بدها تتوجه للمطاء، لمين بدها تتوجه؟ مين عنواني؟ هل بدي اتوجه لدرعي؟ لمين بدي اتوجه؟ لدرعي ولا لمين بدي اتوجه؟ فيش عندي عنوان واضح. هاي كمان مشكلة اللي هي نتيجة البنية التحتية. ففي تطابق، انا بسمي هاي الحالة بسموها هذا بالفلسفة overlapping consensus. مرات بصير في تطابق في المصالح بين جهات مختلفة اللي بتخلي الاشي موجود، بس بصير في تطابق. الوضع القائم هو نتيجة تواصل او تطابق بين عدة مصالح اللي من الطرفين بيجوا بيقولوا انه هذا إلا منيح. وهون انا بدي اوجه يمكن سؤال بس اذا بقدر لأيالت. A question for Ayelet. And this is something we had a discussion, me and Ravia, when she was writing her PhD thesis. We came to this juncture when we said, okay, so this is the attitude of the government. It sees the population growth among the Bedouins as a population bomb. Why isn't it indicting people? Why isn't it really fighting polygamy among the Bedouins? it should be in the government's interest to fight polygamy, okay? Convict people, put people in jail, but it's not. But it is claiming, day after day, the claims that we heard about. So how do you explain this? On the one hand, being so frightened of the population growth, it's a problem, it's a curse in Israel, but the government is doing nothing with polygamy.
بالنسبة لسؤال مها، بالنسبة للوكالة، يعني احنا ما ننسى انه التعديل اللي صار بال 2001 هو عمل نسوي. يعني النساء اخذوا زمام الامور وقرروا انه احنا مع كل الصعاب والتحديات اللي كانت وكيف بدكم تتوجهوا للكنيسة الاسرائيلي ومش عارفه ايش، مشيوا بهذا المشروع. بس اذا بنتبع اللي عم بيصير بالمحاكم الكنسيه، لانه بالذات موضوع الطلاق ما فيش طلاق للكاثوليك، وهي يعني مشكله كبيره. بتشوفي شو بيقولوا مانوفرز بالعربي المناورات اللي بيعملوها، اللي يسموها انه التحول من المذهب الكاثوليكي للارثوذكسي. هاي كان بالذات مبادره اللي هي بالاساس النساء اللي بادروا فيها. يعني في اكثر نساء اللي مشوا بهذا الطريق، وعم بيكون في نتائج. انا بوافق مع اللي حكى مخيل انه بيكون في ضغط. اعطيك مثال بس هيك عيني. قبل كان شبه مستحيل ابطال الزواج عند الكاثوليك، شبه مستحيل انك تثبتي انه انا موافقتي على الزواج ما كانت حرة، يعني كان ناقصني الكونسنت، ما كان صحيح، وبالتالي الزواج لازم يكون بطلان، يعني مش كأنك مطلقة، كأنك ما تجوزتيش. كان شبه مستحيل. لما انا تعلمت جامعة حيفا يعني out of question، شبه مستحيل. لما شافوا اللي عم بتسوي النساء ان عم بتحاول تروح للمحاكم الارثوذكسية، صاروا يفطنوا انه بامريكا الكنائس عشان ما تخسرش كمان كاثوليك، شو صاروا يعملوا؟ كل واحد ماضي اللي بسموه pre-nuptial agreement على شو بيصير بعد ما نتطلق. كل واحد ماضي على هيك اتفاقية. الكنيسة قالت مجرد انك انت مضيت على هيك اتفاقية اللي فيها بتحط انه ممكن تتطلق في يوم من الايام، معناته انت زواجك ما كان كاثوليكي، الكونسنت مش صحيح، فيه خلل، فبالتالي بنبطل الزواج. هسه هون عم بيستعملوا هاي الطريقة، يعني انجبروا انه شافوا عم بيخسروا ناس، انه طيب تعالوا نصير زي امريكا، انه اذا انتم ماضيين على بري نابشوال اجريمنت معناته هذا مش زواج كاثوليكي، باطل. في ناس بمضوا تقدري يعني انه عم بحاولوا بدهنش يخسروا. بعدين كان ياخذ سنين بطلان الزواج، اليوم صار اسرع بكتير، فبالتالي بتشوفي في هاي. بس انا بدي ارجع على نظام الملل، على ملاحظتك. صحيح انه هو بالاساس عثماني، وبعدين الكتاب راوية ممتاز بيحكي كيف الانتداب البريطاني شاف انه هذا بخدمني، بخدم مصلحتي، بدي امشي فيه. بس انا بفكر كمان اسرائيل بتتعامل معه من نفس المنطلق، حتى لو الاساس هو عثماني، بس لما وصلت قالت بخدمني، ممتاز، بدي اكمل فيه. وانا بفكر انه ما نستهين بهذا النظام. دول اللي بتقول فقط اليهود إلهن حق تقرير المصير في هاي البلاد. شو يعني بس اليهود إلهن حق تقرير المصير بهاي البلاد؟ معناته الموارد الطبيعية في هاي البلاد تستعمل فقط لمصلحة اليهود. في أحسن حال أنت كفلسطيني ممكن تطلب يعني أكسس منالية، بس الاستعمال هو لمصلحة اليهود، لتطور المجتمع اليهودي. حق تقرير المصير بقول انه احنا ككوليكتيف كمجموعه بنقرر النظام السياسي بالبلد والاقتصادي وهيك. لما انا بقول انه بس اليهود بيقدروا يعملوا هيك، معناته بقولوش فيش عندنا حق يقرروا هيك. هاي امتيازات مش يعني ثيوريتيكال، هاي امتيازات اراضي، بناء، مشاركه في الحياه السياسيه. لما انت بتنطي مجموعه امتيازات وبتحرم مجموعه ثانيه من هاي الامتيازات، بدك فاصل، مين جوا ومين برا. فقط نظام أحوال مثل الموجود بإسرائيل اللي بيعمل هذا الخط. إسرائيل بتقدرش تشتغل بدون هذا النظام، تزبطش لما هي تستثني الفلسطينيين من حق تقرير المصير. فقط لما احنا بنصير جزء، بصير لنا معترف بحقنا لتقرير المصير، ممكن يتغير النظام. بس انه بتزبطش، ما انت بتنطي امتيازات لناس وبتحرم امتيازات بدك. كمان بامريكا كانوا منشغلين في امريكا كان في قضايا مين هو الانسان الابيض، والسوريين على فكره للاسف شاركوا. كان في قضايا للسوريين في امريكا وقت الفصل الهاي. هل كوني ابيض هو اشي بيولوجي ولا اشي ثقافي؟ يعني لازم اكون اوروبي ولا بس اجى عن بشرتي بيضاء؟ السوريين راحوا قالوا احنا بيض، لازم يكون بيولوجي. خلاص اذا منظري ابيض ابيض انا بدي الامتيازات. فبالتالي انا بفكر انه ما نستهين. وعشان هيك انا بفهمش صراحه الاحزاب العلمانيه كيف انه هن مش فاهمين انه هذا النظام هن اول ناس لازم يهاجموه. شو عملت اي احزاب علمانيه؟ الاحزاب اوكي عندها توجهات علمانيه. طيب خلاص ليش احكي كثير؟ يلا
No, I'll be brief. And I would like, it's okay. I'm in a minority here, right? But I'll be brief nevertheless. I love it. I'm so excited to be here. It's like, you can't imagine. I'm being here and posting all kinds of protests on Facebook. על אפם ועל חמתם, you know, coexistence and partners from all groups in Israel and Palestine. So I would like to answer about the question about agency regarding our own research. While listening to polygamous women, even while hearing the most dreadful stories and really difficult stories about political violence and difficult realities and so on and so forth, you could have see the agency of women, and they always describe how they try to overcome their obstacles and how they're coping and what they're trying to do, and to some extent succeeding in doing it, protecting their kids and protecting themselves and so on. And I think that while discussing agency of women, I could find this more while conducting group interviews rather than individual interviews. And in our research we held both group interviews and personal interviews. And there is something about group interviews and the dynamic within the group that they encourage one another, and they actually push one another to do unconventional things and which steps to do, and to go to Bituach Leumi or to go to this and to go to there, and you can find the answer here and you can have the answer there, and talking among themselves. You know, in local elections we vote by the tribe. And then one woman said to her friend, you know, but when you stand in the Kalpi, nobody sees what you put in there. And then she said, oh, and then they were laughing among themselves. So it's like there was something about this dynamic of the group interview that was also, I wouldn't say providing agency to the women because it's within themselves, but something about the dynamic that was enabling to be even more agendic. So this is one thing that I would like to say. The other question was of Michael's about why, in fact, the state is not until up to now stopping. I think basically they don't care. They don't care about the women. They don't care about the ontological security of the women. They care about ontological insecurity, and if you put it by priorities, then land is first. So let's just, you know, do whatever we can do in terms of land. And also they have all sorts of arrangements with leaders within the community that would like to keep. But I also think that it's not so easy to, you know, when you have public policy and you have some idea, it's not so easy to put it on the ground. So this is also a thing that we can discuss. But I promise to be brief.
ملاحظة سريعة، ليش إسرائيل ما إنه يعني في تناقض إنه إحنا بدنا نحارب بس مش عم نشوف في لوائح اتهام. بس لاحظوا إنك تحارب الظاهرة مش بس لوائح اتهام، روح على التأمين الوطني شو عم بيصير هناك. أنت بتحارب الظاهرة مش بس إنه اللي بدأت أودي الناس الرجل اللي عنده متعدد الزوجات، في حرب على قسائم الأراضي. لما أنا كنت بعدني بآكري من قبل كتير سنين، كان في مشروع قانون إنه امرأة بدوية مطلقة اللي بتعيش بحارة جوزها، الادعاء إنه هي مش مطلقة، هذا جروشين فيكتيفي صوري هذا الطلاق، عشان هي بدها تروح تاخد مخصصات من التأمين. فتخيلوا عشان عايشة بنفس الحي إنه إسرائيل مهتمة للأرض وعلى السيطرة على الأرض وموارد، فبالتالي ملاحقة تعدد الزوجات مش حتما ملاحقة الرجل متعدد الزوجات، هي ملاحقة اقتصادية وأراضي وتأمين وكذا. وهون في تغيير بالسياسات، وبتخيل راوية بتقدر تعقب أكثر من هي مختصة بالموضوع أكثر.
شكرا سونيا. انا كمان بدي اقول انه كمان احنا بدفاعنا مرات بنستعمل الخطاب نفسه. يعني كان في مقاله باحثه اسمها ليليان ابو طبيخ، حاولنا نجيبها على الزوم ما زبط. ليليان برضه بتناقش بتنتقد الالتماسات تبعت عداله، بتقول عداله لما يروحوا يطلبوا ارض او يدافعوا عن حق انسان بارض بيقولوا عنده 5 اولاد، هذا الزلمه بيقولوش عنده 5 بنات، بيقتلوا اولاد الذكور. احنا عشان هذا الموضوع دعينا سوسن، فبكره سوسن رح تحكي عن الادفوكاسي بالقضايا الجماعيه من منظور جندري، فبتامل يطلع هذا النقاش. وبس كمان عشان ذكر كتاب سونيا وذكر موضوع الايجنسي، الاستاذه ما حكيتي، احنا في اصدرنا العام من لجنه الاحوال الشخصيه كتاب عن مسار النضال، يعني فيه 3 مقالات، واحد منهم مسار النضال اللي قمنا فيه بقضايا الاحوال الشخصيه، فبتلاقيه. وبكره احنا عاملين جلسه على شرف في كتاب راوية ابو ربيعه عن تعدد الزوجات، وهو عن ناتج عن الدكتوراه تبعتها، وهي رح تحكي طبعا بكره. احنا معنا نبيله طلبت وحنين طلبت، واذا في كمان حدا بنعطيه احتراما لكم بنجاوب وبننهي الجلسه عشان ما تتعبوش عشان ما تتعبوش وتهربوا من الجلسة. نبيلة
شكرا عرين على انك ذكرتي البحث اللي انعمل، وانا كنت بدي اقول انه كمان لنخيل وكمان انه اذكر في انه في كانت لجنه الاحوال الشخصيه اللي بتشتغل من 94 على الموضوع وبتشتغل على التغيير، وهذه قمه الوكاله اذا بدكم من حيث النضال. وبالنسبه للوكاله انا بفكر انه في كل محل في قمع للنساء في وكاله للنساء، فيش باي تاريخ باي مجتمع باي محل خليت النساء من المقاومه بطرق مختلفه. وبفكر انه في عندنا كثير ضعف في دراسه طرق المقاومه تبعت النساء في ظل الاحكام اللي موجوده وفي ظل الظروف الموجوده. احد الطرق اللي كانت موجوده كمان انه في بعض العائلات النصراويه كان في ينحط بند بقضيه وكالة المرأة على إمكانية إنها تكون الحكم بإيدها، وهذا عمليا في بعض عائلات الناصري كان كممارسة. وإحنا في لجنة الأحوال الشخصية أثرنا هذا الموضوع لأنه كان في ستاندر العصمة بإيدها. نعم، وكان في لجنة الأحوال الشخصية أثرنا هذا الموضوع بقضية الاتفاقية اللي كان بوقتها لما اشتغلنا على هذا الموضوع قدام القضاء الشرعي. كان في اتفاقية ستاندرتت اللي مضوا عليها وما كان فيها العصمة وما كان فيها إمكانية احتكام حتى على قوانين الدولة على بهذا الموضوع. واشتغلنا على الموضوع وغيرنا الأمر كمان في قضية الاتفاق الستاندرتي اللي تغير. بالنسبة لمخيل لموضوع الايجنسي لموضوع الاكزيت، وبقضية المثل اللي جبته عن عن الأصلانيين في أمريكا، وكون كأنه اختاروا لأنهم عندهم استقلالية، هذا عمليا خلاهم يمكنهم من أن يعملوا الكازينوهات في قلب الهوم تاونز تبعونهم. وأنا بسأل حالي هل هذا خيار كان ولا هاي سياسة طمع وسياسة سيطرة، لأنه دخلوا كانت مثل ما إحنا اليوم بنشوف في قضية الجريمة إن إحنا الساحة الخلفية لإسرائيل، وكل الممارسات تبعت الجريمة بتتشرعن من قبل الدولة وكأن خياراتنا، فهي نفس الكنترول. وهذا اللي بيخليني أذكر سونيا بقضية إنه الكنترول المدمي، هذا إنه إحنا عندنا كأنه كنترول مدمي. القضية الأخيرة اللي بحب عشان ما أكونش طويلة، القضية الأخيرة اللي بحب أثيرها إنه كل الاحتكام للقضاء والحكم الديني هو مش عشاننا بس، هو كمان في بعد تبع الستاتوس كوو تبع المجتمع اليهودي، وحاجة الصهيونية للدين من أجل استمرار الفكر الصهيوني وتأسيس الفكر الصهيوني. وهذا بننساه كثير مرات في تحاليلنا لذاتنا، في حاجة إن نحطه كمان كواحد من القضايا. فالقضية مش قضية واحدة، القضية مركبة بما فيها البعد تبع النضال. وبس بحب إني أذكر إنه بتاريخ لجنة الأحوال كمان عملنا دراسة عن أصوات النساء، وريهام أبو العسل عملت البحث وجابت أصوات النساء من البوليغاميا، والأصوات كانت متعددة ومتنوعة ومختلفة. مش كل النساء جابوا بأنه لقينا نماذج مختلفة في قلب العائلات هذه، لقينا نماذج تضامن، لقينا نماذج اللي فيها رفض، لقينا نماذج متنوعة. وهذا البحث اللي عملتيه أنت عرين كمان اللي أرجى قديش في تنوع في الوكالة تبعت النساء في قضايا مختلفة في داخل مجتمعنا. شكرا.
مساء الخير وشكرا مدى والمنظمين وشكرا للمحاضرين. أنا عندي سؤال، إنه بركي إحنا نفترض عقلانية أكبر من اللازم للمستعمل، إنه دايما بيعرف التقسيمات الصحيحة لمصلحته. يعني قد يكون إنه إعطاء استقلالية، ما يسمى استقلالية ثقافية بشكل محاكم شرعية، لا بالضبط، هي خاضعة كمان للتجربة. يعني في حالة خلقت هاي الاستقلالية فعلا حراك ونقاش فكري وفعلا تغيير داخلي، قد يكون بتبعيد النظر فيها المستعمر. يعني المعادلة مش وين أحسن، مش إيش أحسن، الأحسن مش ثابت. يعني قد يكون أعطي إكزيت، ساعتها بصير من مصلحة الدولة تعطي إكزيت أكتر وتعطي إمكانية تحمي المرأة إذا شافت إنه هي حمايتها للمرأة أفضل من الحماية الداخلية. يعني القضية مش إنه أنا بديش أحميها، أنا بديش أحميها لأنه هي مش رح تاخد الحماية الداخلية في مجتمعها، اللي هي الحماية الداخلية تعمل حراك وقوة اجتماعية وقوة فكرية ويستفيدوا من هاي الاستقلالية. أنا بعطيهم الاستقلالية عشان مش رح يستفيدوا منها، هي بس رح تفتتهم. يعني لما أنت قلت ميخائيل إنه في هنا ترابط مصالح بين اللي ماسك القوة اللي ماسكة هاي الاستقلالية، لو القوة اللي كانت ماسكة هاي الاستقلالية تقدمية وخلقت حراك الدولة ما فكرت فيه، كان فورا بتسحبه وساعتها بتقول لا أنا من مصلحتي أعطي هاي الحماية، أنا بدي أعطي الحماية. بتكون ساعتها الحماية وسيلة اندماج، وسيلة أسرلة، مش دايما الحماية للمرأة وسيلة empowering. إذا إحنا حطينا الدولة في خيار أنا أحميها كدولة ولا شعبها ومجتمعها يحميها، ساعتها لا، الدولة رح تختار أنا أحميها. من يعني القضية مش دايما الدولة بتفحص زي تعدد الزوجات، الدولة مش عارفة تحاربه ولا لا، غير وهذا اللي انت حكيتيه سونيا، او اذا مكتوب رابية حكته عن الارض، الدولة مش دايما بتعرف مسبقا مثلا تحارب تعدد الزوجات ولا لا، تعرفش تعطي المرأة تتعلم اكثر الفلسطينية ولا لا، اخلي المرأة جاهلة. طب اذا هي جاهلة، اذا هي ما فيش افاق تطوير، ممكن تخلف اكثر وساعتها في خطر ديموغرافي. الدولة دايما بتفحص ايش الافق، مش بالاول، يعني مفيش راشوناليتي هالقد، مش مسبقا هي بتعرف احارب تعدد الزوجات ولا لا. ممكن احاربه وساعتها النساء يتعلموا اكثر، يقووا اكثر، لا يخلفوا افضل مما يقووا مثلا. ففي شيء هاي يعني انا بحس انه احنا زي منحط الدولة قدام، او هي عارفة حالها حاسبة، لا هي كمان بتفحص وبتفحصنا كيف نتصرف. وقد يكون هاي اخر شيء بس بدي ارجع عليها، قد يكون لو احنا بنتصرف صح بهاي الاوتونومي تصير اسرائيل بدها تحمي المرأة الفلسطينية، انه انا احميها لانه انا بديش حمايتها الداخلية، بالعكس تقوي وسائل قوة داخلية إلهن كشعب.
بس جملة واحدة بس حنين على قصة النقاشات هاي، موجودة بوثائق الحكم العسكري بالضبط. هذا النقاش طلعوا بمقال له الأستاذ أحمد سعدي، إنه نخليهم يتعلموا أكتر بركي بيخلفوا أقل ولا ساعتها بيقوا علينا وإيش نعمل. هاي النقاشات من الخمسينات كانت موجودة عندنا.
Thank you. So I will briefly answer. It was general, but I had a comment when I hear you speak about protecting the women, and I think that what is interesting to see that mainly in deeply divided societies, and this is related to a different study that I conducted, we see that right-wing government are very much in a hurry to protect the women. But what they do is they do it not so much in order to protect the women, but also in order to curtail minority rights. And this is why you see Modi, right, in India, very much in a hurry to curtail the Muslim rights over there. Because, no, I'm liberal. I'm a liberal. I know what I'm doing. And I need to do this for the women. And this is true also in the Israeli sense, that those who are rushing into disrupting and doing these elements, because when you do that, it doesn't come with a package of rights and money for education and for jobs and other things. It comes specifically in order to curtail minority rights. So that's a thought that I have following your question, and I'll
لا، الجدال بالنسبة للإكزيت والفويس، الحق إنه هاي ميكانيكية واحدة للتغيير. هذا جهاز واحد، في عدة أجهزة تانية اللي ممكن تحفز التغيير، وحكيت عنها في الكتاب. يعني إحدى المحفزات وهذا برجع يمكن شوي بتواصل مع اللي قالته حنين، انه كان في عندنا، اذا بتدرسوا انتم السوابق القانونيه للمحكمه العليا وعلى القانون التعديل اللي صار بسنه 2000، صار في عمليه اللي هي كات اند بيست بسميها، بمعنى انه نشوف شو عم بيصير في المجتمع اليهودي لما كانوا يتحدوا المحاكم الربانيه، ونيجي على المحكمه ونقول انه صار هيك هناك، هات نعمل إسا بالنسبة إلنا بالمحاكم الشرعية وكمان في المحاكم الكنسية. وهاي الأشياء صارت كات اند بيست. مثلا مشروع النفقة، إذا أنتوا لاحظتوا شو اسم كان تعديل القانون، حق هشفاءات السمخيوت. قانون التساوي بين صلاحيات المحاكم، مش قانون حق المرأة. انه احنا بدنا نتبع شو موجود عند اليهود، احنا بدنا نتساوى من ناحية الصلاحيات. فهذا كان احنا بالنسبة لنا زي انه هذا هو السقف اللي احنا لازم نوصله، وهاي كانت آلية. بس انا كمان بدعي، وهذا كتبته كمان، نقدر احنا نطلع من الباراديجما هاي حنين، نقدر نطلع منها واحنا نكون الفكر المستقل بدون ما انه نشوف حتى الدولي. انا العالم اللي انا عم بتصوره هو عالم اللي انا بقيم منه الدولي وايش هي توقعات، انا عم بسأل شو احنا توقعاتنا. اوكي، انا حسب رايي زي ما الدولي يمكن مش عارفه شو بدها مننا، انا بصراحه احنا مش عارفين شو بدنا من حالنا بهاي الامور. فهات احنا شو الفكر المبلور تبعنا، شو الفكر المبلور تبعنا احنا في هاي الامور. اترك الدولي بالنا تعرفش، هات نزيحها. انا شو بدي؟ ولقيت مثلا في سابقه واحده صغيره مش كبيره اللي قدرنا احنا نفكر بشكل مستقل، وصلنا لمعادله بتختلف عن شو بيصير حتى بالدولي وشو بدها المجموعه اليهوديه. في قصه البندقاؤوت، الام اللي تأجير الأرحام، لما اجى القانون بسنة ال96، الام اللي بتعطي البويضة والام اللي بتحبل وبتحمل الجنين، مين هن؟ لازم يكونوا من نفس الديانة ولا لا؟ اجوا الفكر الرباني عند الخخامين اليهود قالوا اذا الام اللي بتعطي البويضة بتختلف من ناحية الديانة عن الام اللي راح تحمل الولد، هل الولد هذا بيبقى يهودي؟ ليش؟ لانه امتحان من هو يهودي عند اليهودية بيتبع مين الام، بس مين الام اللي عطت البويضة ولا اللي حبلها. فعشان هيك اجى القانون في بنت 5/2 بقول لك اذا احدى النسوان هي يهوديين، الثاني لازم تكون يهودية. لازم يكون الامرأة اللي بتعطي البويضة والام اللي بتحمل لازم يكونوا تنتين يهوديات، ولكن اذا التنتين بيكونوا مش يهوديات ممكن يكونوا من ديانات مختلفة. ممكن بعدين يكونوا من ديانات مختلفة. اجينا فكرنا احنا خارج الاطار، عرفنا احنا شو بدنا. طيب الام واحدة مسيحية والثاني مسلمي، ليش يعني فيش عندنا هذا السؤال من هو المسلم من هو المسيحي زي ما هو موجود من ناحية عند اليهود. نقدر احنا نفكر خارج الاطار. وانا اخذت هذا المشروع كمان خطوة لقدام. هات احنا نبطل في قانون التبني، في قانون التبني في تطابق بالاديان حسب يتم التبني في لبنان. ان ما قامتش الا ما بين بطوشي لمؤمات. بنت 5، هذا بنت واضح. عند اليهود لما وضعت الاشي وشفت ليش، عند اليهود كان في عندي نوع من اشي تاريخي، سنتمنت بحترمه. اخذوا اولادهم وقت الكارثة اليهودية تبنوهن غير يهود في مؤسسات دينية مسيحية، كان اشي بالنسبة لي طبعا انا بحترم اذا الولد يهودي يكون المتبني من اليهودي، بس ليش يكون عندنا كمان؟ ليش اذا الولد مسلم ولا مسيحي لازم يتبنى؟ مش بس مسيحي، ممكن يكون يعني عندنا المسيحي اذا روم ارثوذكس، الروم الارثوذكس هي ديانة يعني. لا بس حتى تعرفوا هذا الاشي مؤلم. ليش؟ لانه في اولاد مسلمين بالاخص، وهذا الاشي تدون وموجود بالبروتوكولات، بيطلعوها من اسرائيل حتى يتبنوها باسكندنافيا عشان يكون متبني مسلم. لا هذا مدون موجود. ليش انا مع انه احنا مرات نفكر الدولة بعرفش بدها ولا بداش. كان في اشياء واضحة مرات عند الدولة، بس اذا احنا نروح انه الدولة متذبذبة ومش عارفة، طيب احنا كمان نقدر نفكر بشكل مستقل، واحنا على القليل نعرف شو احنا بدنا حتى نعرف شو نطالب. بس هذا انا بقول انه الدولة فيها تذبذب ومش واضح بالنسبة لها. بس بعرف هاي بلبنان يعني بشوف مشروع لبنان فيها جدال حر عن الزيجي. هسا في تنظير عن لبنان بتواصل مع اللي قالته سونيا، لانه المواطنة في لبنان هي مواطنة مبنية على الديانة وعلى الطوائف. فلما في فجوة من ناحية شو معنى المواطنة، معناته ما نوجدش، احنا ما بنقدرش نوجد الإطار العام. هذا مزبوط كمان، هذا مزبوط. في هاي الامور حتى نقدر على نبلش، حتى نقدر نبلش نفكر، نبلور فكر مهم.
بس انت استاذ جامعه وبتعرف انه بنحترم الاوقات. سماح
لا في معيد الف وفي معيد ب.
انا صباحي قاعده هون، بس انا بديش الناس تقعد تتململ، وعدناها لنا 7 الساعه 7:30 بكره. بس بكره عندنا صح، بس ما بدهم يسمعوا النقاش الناس. بكره عندنا نهار طويل. اوكي ذيس از بيرفكت. طيب خلص انا مضغوطه عنكم، انا قاعده صباحي ما عنديش مشكله، بس يكون واضح. طيب
انا حسب رايي احنا بنخاف يكون في عندنا خطاب علماني واضح.
طيب بس في مش بس هيك، بدي ارجع للنقطة اللي ذكرتها حنين واربطها مع باقي الشغلات. انا بوافق 100% مع اللي بتحكي، انه احنا في عنا فرضية مسبقة انه الدولة عارفة بالضبط شو لازم تعمل. انا بفكر الاهداف، يعني شو اللي بدنا نوصل، ايش اللي بدي احافظ عليه واضح بالنسبة للدولة، بس كيف بدي اصل لهذا الهدف ممكن يكون في مرات اشياء متناقضه. يعني من ناحيه انا بدي ان النساء الفلسطينيات يتعلموا عشان يخلفوا اقل، بس من ناحيه ثانيه انا بدي اقوي مكانه القيادات التقليديه، لانها ولائها بده يكون، يعني في مرات حتى بالدوله هي توجهات فيها تناقض. وعلى فكره هذا مش إشي بس باسرائيل، كمان اذا ندرس كمان حاله السكان الاصليين في امريكا، سياسات امريكا كانت كمان متذبذبه، بدهن الارض هذا واضح مع اقل عدد ممكن من السكان الاصليين. مرة بدنا ندمجهن، مرة بدنا نوديهن على ريزرفيشنز، مرة بدنا هاي. الهدف واضح شو هو، بس كيف بدأ ساعتها بصير تخبطات، واحنا لازم نكون واعيين لهذا الاشي ونلعب بها. يعني هاي مساحة مناور. بالنسبة للمحاكم الكنسية، شوفوا هن عندنا استقلالية كاملة، يعني ما حداش بيقدر يسألهن شو بدكم تعملوا. طب أنا السؤال بسأله، انتوا حرين، انتوا بتجيبوا قانون من الصين من الهند، ما حداش بيسألكم. بالسلطة اليوم في نساء قاضيات في المحاكم الكنسية، في المحاكم اللوثرية. المحاكم اللوثرية عملت ريفورما يعني رهيبة. بالأردن المحاكم الأرثوذكسية طب انتوا مين منعكم تعيين؟ انتوا فيش عندكم المحاكم الشرعية كان في قوانين ممكن تمنع تعيين قاضي مثلا، بس هون فيش عندكم ولا أي مانع. هن بدهنش مش واعين إنه أنا معي فرصة هون إني أثبت إن أنا أحسن. المطران جورج بقعوني اللي كان مطران بس إسا رجع على لبنان وهو لبناني، طلع مرة في برنامج حكى أنا أؤيد الزواج المدني. أحزابنا بتسترجيش تقول أنا أؤيد الزواج المدني. ورجل دي مطران، كان مطران، قال أنا بدي حرية إلي، أنتوا بتفرضوا علي، أنا بديش حدا يجي يتجوز عندي وهو مش مقتنع. أنا بدي الناس تيجي تتجوز عندي تكون مقتنعة، وبديش تفرضوا عليهم يجوا، وكمان أنا بديش تفرضوا علي كرجل دين أجوز ناس اللي أنا مقتنع إنه هن بدهنش يتجوزوا عندي، إن هن مش ملائمين، عارف إنه بدهم يتطلقوا كمان 5 سنين، أنا بديش أجوزهم بكنيسة كاثوليكية.
فالمشكله انا بوافق معك انه احنا بنقدر نعمل بهاي الاستقلاليه اشياء الاسرائيل ما كانتش مخططها لنا، بس احنا اللي مش عاملين.
بس هذا في شيء واحد، في كمان شيء حكيت عنه بسيط، نيجي نغير البنيه التحتيه مره واحده حسب راي هذا كمان، ولكن احدى الاشياء اللي اقترحتها يكون في شفافيه. قرارات المحاكم الكنسيه كلها تنشر، انشروها. بدي اياها يستحي لما يكتب الاشي ينشروها. ما لا بقولوا في خصوصيات لاولاد، منيح احذف اسامي الولد. طب ليش يعني القرارات عند بالمحاكم اليهوديه تنشر؟ انشر. انا بدي انه ينشر، يكون في شفافيه كامله. انا بدي اعرف هذا القاضي كيف بيكتب، بيعرف يكتب باي لغه بده يكتب. فهاي احدى الاشياء، شفافيه. انا بدي انك تقول لي ايش قرارك، تفسر. الكاي فيش، هذا مش موجود. انه نيجي احنا بشكل مباشر لما بحكي انا عن الاكزيت، يعني الاشياء واضحه. ليش؟ لانه بتيجي على فرضيه انه تيجي اسا تقلب الوضع القائم من صفر تعملوا 100. هذا اشي مش راح يصير. اشي كمان انه نقدر نفكر، وهذا كان تفكيري من ناحيه واقعيه، نعمل محفزات اللي هي اللي بتقدمنا يمكن ب20 سنه بدا الاشياء تتحسن، بس كيف ممكن نخلق الحافز هذا؟ كيف ممكن؟ فهاي الاشياء اللي جربت انا اوضحها، قصه الاكزيت والفويس، الكاتن بيست. نشوف شو في كمان عم بصير. احدى الكاتن بيست انا بسميها اورجانيك كاتن بيست، اشي عضوي. ننقل الاشي بشكل عضوي. هات نشوف شو عم بصير في استحداثات في مصر، في المغرب، في تونس. بلاش تقول لي روح على فرنسا، لا، هات نشوف في كثير اشياء هناك عم نصير، نجيب من هناك. وهذا الاشياء ممكن زي الخلع مثلا في مصر، مش اشي مثالي، بس نسبة للي موجود ممكن هاي كمان فحش. لمين فيش استقلالية؟ بس اشياء صغيرة صارت، مثلا ان امرأة تكون قاضية في محكمة شرعية. اذا بنشوف بنسلسل مثلا تقدم مش انه تقدم. اوكي، كيف صارت؟ بس كيف صارت؟ صاروا يقولوا يكتبسوا انه صار في السلطة.
مجتمع حي بيوصل. ثورة كانت على الشعب. مش عامله، مش بتبنيته كاجنده، المحاكم بتتبناه كاجنده.
عشان هيك هذا الحراك، اذا في عندي امل من هذا الحراك انه انا من ناحيتي حتى هاي الشفافيه. انا بالمقترح الاساسي للمؤتمر انا كان بدي قضاة المحاكم الشرعيه وقضاة المحاكم الكنسيه تتواجد في المؤتمر وتحكي.
دعينا بس ما احنا دعناه، انت وحده اعتذرت ما ضبط معاها لاسباب يعني بس انا كانت غير بدي تقولي معها.
تمام. لا طيب ماشي. اريج عنده ملاحظه وعلي عنده ملاحظه، اذا بنفع كومنت فيش حاجه سؤال، بنفع ملاحظه كمان.
جزء سؤال. اول شيء شكرا كثير على دائما من لما ندرس دراسات نسويه ميخائيل اخذ النقطه قضيه انه اهميه وجود قضاء، وهذا كان يعني الامور ليش؟ لانه انا شايفه حقيقه يعني المؤتمر يعني واحده من الامور الاساسيه والمهمه فيه هو كيف البحث بيخدم الحق. كل المساهمات واللي حكته نبيله واللي حكى كلهم يعني هذا اكثر موضوع احنا بنقدر على الاقل لانه بخص مجتمعنا نخدم فيه الحق. فشكرا لكم اشعاع الابحاث، لانه يعني مهم انها تطلع. وانا يعني هون بقطع شوي كمان مدى اذا مركز ابحاث تطبيقيه تطلع للقضاه وللناس اللي يعني مهتم نوصلهم اياها. هاي الملاحظه الاولى. انا بفكر سماح قضيه رد الفعل، انه ليش احنا دائما بنرد فعل. انا مش عم ببرر، بس انا بدي اوصف الحاله انه احنا تحت عايشين في حرب مستمره على كل الشباب. فاللي عم بيصير احنا عم نرد فعل مش تبرير. يعني في مرات تانية احنا ما بنرد فعل، هذا وصف لواقع اللي احنا بحاجه نطلع منه. بس كتير مهم انه ما نضل من محل نذنب ذاتنا، لانه انا بشوف كمان مره بالحقل النسوي والنسائي اكثر مجموعه فعاله عند الفلسطينيين في ال 48 لليوم، من ال 48 لليوم هي النساء. وهذا إشي مش يعني في قضايا الجريمه والقتل والعنف والسياسيه. اوكي بس انا عم بحكي عن الايجنسي يعني كمان الوكاله بمفهوم قديش احنا ممكن نتحرك كمان فكريا معرفيا، وهذا مؤتمر يعني معرفي ابستمولوجيا في إشي مهم نشوفه. الملاحظه الاخيره لأيالة، thank you for your contribution. I'm just suggesting and thinking with you. I am afraid of using the terminology of ontology, even if the state uses it. I think we as like scholars, we can describe what the state say, but I think that we have a role to theorize critically the terms, because these terms generate a specific consciousness among the Israelis themselves. I would use, for example, instead of ontology, something else. Maybe racialized security. I would use myself colonial security. I don't want to impose my theoretical lenses, but I think coloniality, especially with the case of land that you talked about, and that this is the pillar of talking about Israel as settler colonialism, not as an ideology, but as an analytical perspective. This can transform our theory to be epistemologically decolonized. And this is our role as part of thinking critically about how can we generate knowledge about the polygamy, which I feel bad when I hear the word, differently in Israel, in Hebrew, because this is reproducing the structure of knowledge that we are trying to defeat and deconstruct. Again, this is not a criticism, this is an invitation to correspond with our field differently. And thank you, of course.
كان في هناك حديث من عدة أصوات عن مسألة الأحزاب، وأنا طبعا بديت كلامي بأنه حكيت جملة إنه خوفا من خشية من الجمهور المصري، لكن بنفس الوقت إذا إحنا نقرأ مجتمعنا التطور من محل إلى محل سلبا أو إيجابا، كمان ما بنفع إحنا نهمل دور الأحزاب والفضاءات والمظلات والأقنية والمساحات اللي خلقتها أصلا لمناقشة هذه القضايا. وهون على الطاولة في غالبية الناس موجودين إما كانوا في أحزاب أو مؤسسات مجتمع مدني لها صلة بأحزاب، أو كتبوا في مجلات لها علاقة بأحزاب، فبالتالي في عقود من تاريخ تراكم المعرفة والتجارب والخبرات اللي المظلات الحزبية المتفاوتة. حتى على فكرة الإسلامية إذا كانت العصرنة مرتبطة بالتنظيم، والعصرنة بالتنظيم تؤدي إلى أحيانا تؤدي إلى وعي وتنوير وبالتالي إلى احتمال علمني، وهذا بعتقد اللي فتحه الدكتور عزمي بشارة في مشروع اللي هو العلمانية في السياق التاريخي، اللي هو بيحكي عن نماذج متفاوتة من العلمانية، وبيحكي عن علمانية صلبة وعلمانية مرنة. فبالتالي الحديث عن علمانية واحدة وكأنه الجواب الجاهز أن العلمانية بالضرورة في الضد وفي المقابل من الدين، هو لا، لأنه المؤسسات الدينية حتى في بعض الدول الأوروبية ساهمت مع حضور العلم ومع حضور الفنون والآداب في علمنة نفسها وبالتالي علمنة المجتمع. فالمسألة هون مش العلمانية بالضرورة وبشكل أوتوماتيكي هي في الضد من الدين، هي مسألة. المسألة الثانية الحديث المباشر عن ما في حزب رح يمنع الناس شو تعمل. فرضا فيش عندنا أحزاب، فرضا طلعت إسرائيل بكرة منعت كل الأحزاب مثل ما جمال عبد الناصر عمل أو آخرين، شو بنعمل؟ نسكن؟ لا، المجتمع المصري تطور، والخطاب المعارض النقدي الرفضوي فيما يتعلق بحقوق المرأة والإنسان والمواطن استمر حتى في ظل منع صحف وأحزاب في عدة دول في العالم. علينا نحن كنخب أكاديمية وإعلامية وصحفية واقتصادية وفنية بكل أنواعها أن ترى في نفسها عنوانا للقيادة، وأن لا تتكل وتتكئ وتظل مطالبة طيلة الوقت. يعني مثل ما بيعمل ابن خال المجتمع الإسرائيلي، تنزلوا على الشوارع وبتسكروها زي ما بتعملوا بتل أبيب من دون ما حد قيادي يطلب أو بيضرب قيادي. بالتالي المبادرات الشعبية ليست بحاجة دائما إلى هيرارخيا ومركزية وسلطة، وإحنا عندنا تجارب من مجتمعنا برافر وطالعات وغيرها، وهاي نماذج تحتذى في العمل وبتنظيم النفس. أما البقاء جلوسا على الدكة وانتظار المخلص على شكل قائد نجم، فهذا لن يؤدي إلى شيء.
علي وين شايف هذا الشيء؟ يعني الحراك النسوي من سنوات الثمانينات وهن يحكوا وكسروا كل التابوهات المجتمعية.
أنا معك، أنا معك، هذا اللي بقوله، هذا اللي بقوله.
يعني بعرفش حاجة هيك.
لا هذا بالعكس، هذا اللي بقوله. أنا معاكي إنه حاضرين إحنا من دون والأحزاب لعبت دور ما ننكرش، يعني صحافة وبحثا
شكرا علي. أعطى بس كومنت، بس بما إنه أريد سألك نحكي بس أيام تجاوب وبقول
Yes. Thank you so much for your comment. I will briefly answer that in the paper we relate to other theories as well in terms that are used. We specifically used ontological security and insecurity as an excuse of the state, or maybe use of ontological insecurity in a cynical manner, because it happens both in colonial areas and both in other areas. And we see that in many states, those also that are not related to racial relationships or to colonial aspects or perspectives. So this is why we thought it is really, really useful, both in terms of the contradiction between the perspectives of the women themselves of severe ontological insecurity and the trial of the state to produce so-called ontological security, and also shedding light on the ontological insecurity that minority women often cause, allegedly, to societies and states. And I would love to continue this conversation with you and send you the article in full. So thank you.
لا بيقولوا بالأصالة عن نفسي وبالنيابة عن المؤسسات الراعية. بحب أشكركم كثير، أنا كثير مبسوطة، بس أنا خايفة إذا طولتوا إسا ما تجوش بكرة، فمجبورة أنا تبروموت اللقاء تبع بكرة. بتمنى أشوفكم بكرة، يعطيكم ألف عافية. شكرا.